lots of dislikes. Lots of dislikes here. But there's going to be one now, she says. I do. See, oddly, the thing that got the most views by a long way, all my videos, is the one I did years ago. One of the first ones I did was on legal philosophy. And I did it. It was a terrible mic. It just had whatever the mic was sitting on my desk. And yeah, got a lot of views. Don't quite know how that works. But anyway, I'll zoom through this one. This one's only a couple of slides as well. But the last one is going to be a little bit more. Okay, so remedies. What we've got here. In situations where undue influence or unconscionable transactions arise, you get essentially the same ability to rebut it. And that's why I did want to put this as a separate tiny little recording, because when it arises, what it should do, or you can, if it's going to arise, please pop up, okay, or not. For that in a minute. In situations where it does arise, the key thing to note is that you can lead a horse to water, but you can't make it drink. What does that mean? It means that if you think that a particular transaction is going to be tainted by undue influence or unconscionable dealings, you can actually go and still do this thing. You can still have a contract between you as religious advisor and you as a follower. You can rock up and buy some land off a guy who's a raging alcoholic and take over a bunch of booze. You can still do these things, all right? Provided you take certain steps. I'm going to talk about that. I'm just going to talk about the remedies as well. So that's the key part of this little recording. Sorry, these are little recordings, but they sort of logically make sense to be plopped together. Okay, and there's literally only 3 slides. So here, when you win, if you rock up for undue influence and unconscionable dealings, the default remedy you get is rescission. A bit like the right to rescind for common law misrepresentation, although these are equitable remedies. And as such, the court has to say you can undo it. Common law stuff you can just go and do. If you want an equitable remedy, you've got to ask the court to give it to you. And so that list of things, affirmation, delay, impossibility, impact on third parties, these look like the bars to rescission that you would have had for misrepresentation. These are the things that will stop a party from being able to rock up. Orchard and Skinner was an undue influence case involving a religious advisor and a disciple. So a woman conveyed her property to a church, monastery of some sort, and then she wanted to live this life as a nun. So she does that, lives as a nun. Turns out, after 6.5 years, she's like, I don't really want to be a nun anymore. And then went back and said, can I please have my house back? And the court said, nah. Why? You took too long. And look, sometimes that's a little unfair, because we think, well, the undue influence would have been exerted over her for the entire period. Too bad. One of the, I guess, kind of fundamental rules about civil law is this idea of limitation periods. People need the certainty of knowing that once something's happened and a decent period of time has gone by, the rights of the parties in their own lives in terms of debt, in terms of things that you're going to have to owe and pay people who could sue you, have crystallized, have reset to zero. You do not want a society where you have this thought or the spectre of people being able to sue you for things that you did in the 1980s. That is not a fun way to live your life. It's true, actually, if I'd said that with 90s, yeah, I'm just glad the internet wasn't around then, eh? And so that's really what we're trying to do here. Section 10 of the Limitation of Actions Act, 1974, Queensland, enshrines for actions in contract, quasi-contract, and tort, 6 years. So most actions. Some are a little bit shorter than that, defamation and personal injury. Things that involve personal injury is seeking compensation for. Both of those have a shorter limitation period, 1 and 3 years respectively. But 6 years is the default for most causes of action. And strictly speaking, this is equity. And equity can let things run longer because it's designed to remedy defects in the common law. But in practice, if what you are doing in equity is, for example, an action in something like estoppel, which again is a first semester concept, or one of these, 6 years is going to be a really good benchmark for bringing an action. But in some situations, it's going to be a lot shorter than that. The courts can look, particularly they'll look at how the parties and the rights of the parties have settled. Have everybody adjusted to this change in position, gone about their lives? Particularly, have you, as the plaintiff, changed the position, been, in inverted commas, happy with it, and gone about your lives? Looked at the case of the Hyundai, the Ocean Line Shipping, I think it was, and Hyundai. They said that it was like 11 months, but the courts there said that, look, the rights had settled. You'd gone, you'd moved this thing over, and we weren't going to argue in that situation that you're going to be able to go back on that. Allcunn's going to, I think it was 7 years before she rocked up back to courts. It's going to take too long. It's just too long. The rights of parties have settled. One of those things to note is this idea of affirmation. If you demonstrate that you're happy with the result, right, and the way they do look at this is how much did you protest? And that's really hard because often with undue influence and unconscionable dealings, there is no protest. Often, in fact, it's third parties that come and look at what a family member has done and gone, whoa, hey, no, this isn't right. We need to go and get this undone somehow. And that's that idea when people come in to your office, if you guys do end up practicing as solicitors, if stuff like this comes up, get onto it fast. Don't sit on your heels in regards to issues where you've got to get a remedy in equity. Do it quickly. Equity assists the diligent and not the tardy, one of the maxims. Okay, impossibility and this inability to put things back to how they were. Now, strictly speaking, it's actually a common law principle that says if you can't undo a contract, if you can't put it back exactly how it was. Equity was always a little bit more flexible in terms of doing stuff. And so that when they're talking about impossibility in terms of getting things back to how they were, that's not like minor variations that can be accounted for with dollars. So in that Alati and Kruger, it was a fruit shop being sold, all right, and they went through and argued. One of many arguments they had was that you couldn't have rescission because, I'm not kidding, the fruit's gone bad, Your Honour. Can't go back to how you were, the fruit's gone bad. We can't have perfect rescission to put the parties back to where they were. And the High Court said, don't be stupid, just go buy more fruit. Here, we'll adjust the dollar awards accordingly. Equity has that flexibility to do that. Specific performance. Now that's a remedy that we'll do in the second half of this subject. Specific performance is where, usually for the conveyance of land, you can actually ask the court to make a party, in some situations, convey the land to you. So for example, me and Jordan sign a contract, I'm buying Jordan's land, and it's for this sum of money, and we rock up to settlement day, and he goes, no, I don't want to do this anymore. He's in breach, he's going to have to pay me some dollars, but I say, no amount of dollars will compensate me for this, I want that land. And our law, in equity anyway, actually agrees with me in terms of that situation. It's an equitable remedy that commands a person to convey, usually land. It's usually the main time that this comes up. There's a bunch of other little things as well we'll talk about in week 10 or so. But if you are, if you're doing naughty things in equity, all right, so if, for example, this transaction was it exerted undue influence or unconscionable conduct in relation to that. I took situational advantage of Jordan's, addiction to computer games. And I said, let's come and play some Xbox. And hey, yeah, show me your house. I took advantage of that. That's a terrible example, but but in those situations, assuming that you managed to prove that and you didn't manage to rebut it, I could ask a specific performance, hey, I'd like this land, but if I've exerted some sort of undue influence in relation to that, in order for specific performance will be removed. Equity is also flexible in that you can do what's called partial rescission. That means that if there is multiple components to a contract, some of them can be rescinded and some of them can have or use other doctrines, either undo certain parts of it or have restitution in relation to certain parts of it as well. Valdez and Pioneer Concrete involved a guy who needed to basically doing a refinancing arrangement, and he had a supplier, he had a business, wasn't doing very well. He had would do things with cement. Would go and get cement and put in slabs and do that sort of stuff. And he wanted to go and refinance this in some way. And when he went to do this, he thought when he was doing it that it was the debts that he was being released for, or for whatever, guarantor for, was for all present debts. Or it might have been all future. It might have been all future debts. But it turns out when he was mistaken, all right, we know a little about unilateral mistake. What's the default remedy? Nothing. But the other side, in situations that was, again, situations where they were aware of, actively sought to stop him from finding out, unilateral mistake, you had a right to go through and do that. And there they said that, look, you can, in situations where he's mistaken about both the future debts and the present debts, we can allow it to rescind the contract for this clause and not for that clause. So you can split these things up. The courts in equity can do that for these sorts of remedies. Okay. Defences. All right, this is an important one. You will definitely be examined on this. Because when there is unconscionable conduct or there is undue influence in relation to a transaction, if you can prove undue influence, remember it was either actual undue influence, very hard to prove, usually over a long-standing dominance of a will, or a special relationship of trust and confidence, either one of those 6 automatic categories, solicitor-client, doctor-patient, guardian-ward, religious advisor and follower. And there's also the statutory mechanism as well of Section 87 of the... those are the types of relationships where undue influence is automatic. It's automatically presumed. So if I am Martin's follower and he's the head of a religion and we have a contract, by default, I just have to prove I'm a follower, you're my religious advisor. That's it. By default, I win. But in undue influence and unconscionable transactions, the defendant is allowed to try and prove on balance of probabilities that the amount is fair and that you pushed me very, very firmly to seek independent third-party legal advice. That's the rebuttal. You've got to do those things. Notice that said, given the opportunity, is not the same as them actually doing it. So you can lead a horse to water, but you can't make them drink. And with the case with trying to rebut this, if you can prove the transaction's fair, and remember, at common law, we don't care how fair things are. Rachel Bradshaw got a little peppercorn as a gift when she left, because peppercorn is sufficient consideration at common law. We don't care about fairness. In equity, we do care about fairness. When you're going through and doing this sort of analysis, you have to look at the market value of things, because that's one of the mechanisms you can use to rebut it. Hey, this amount was about fair, wasn't far off market value. It's fair and reasonable, an arm's length transaction. And we strongly encouraged the plaintiff to seek independent third-party legal advice and or financial advice. All right, fairness is an objective test. It's a reasonable person test. You guys should be used to reasonable person tests by this stage. And you do not have to insist on it. You can just, as I said, you can lead the horse to water, but you do have to take more than merely a suggestive course of action. You actually do have to be firm. For example, hey, we're going to drive somewhere and then drive to the solicitors. That's going to be sufficient. And I've had this happen in legal practice, so people literally drive to the solicitors, got there, and then go, no, I don't want any of this. I don't want lawyers to get involved. Okay, that's going to be fine. Tick. You've done what you needed to do. But it's more than saying, oh, you probably should go. You probably should go and get independent third-party legal advice. Not sufficient. You've got to take active steps to do that if you want to try and rebut that little that presumption there. All right, that's the end of that little recording. I told you it was going to be short. The last one, I'll start in just a minute.